I'm always looking at that damn clock, it ain't there. Hey, you ready? The Escambia County Contractor Competency Board is in session for the regular meeting August 3rd, 2022. Madam Secretary, would you read the board rules?
Yes, sir, Mr. Chairman. Please silence all cell phones. If you wish to speak, please let the board secretary know in advance. Otherwise, raise your hand for the board chair to recognize your request. When the chairman calls you to speak, come to the podium, adjust the microphone, then state your name and address for the record. You are requested to keep your remarks brief and factual. Both parties of an issue will be granted uniform maximum time to speak. This typically runs between 3 to 5 minutes. This hearing is considered quasi-judicial. Conduct is formal, and profane or derogatory comments will not be tolerated.
Thank you. Madam Secretary, do we have a quorum?
Yes, sir, Mr. Chairman. With 6 members present, we do.
Thank you. Do we have proof of publication and notification of this meeting?
Yes, sir, Mr. Chairman. It was published in the Escambia County Sun Press on Thursday, July 28th, 2022.
Thank you. Entertain a motion to approve the minutes.
Move approval. Second.
Motion made and seconded. Any discussion, addition, deletion? Being none, all those in favor say aye.
Aye.
Opposed, like sign. Being none, the minutes are approved. At this point in the agenda, we have a public forum.
Yes, sir, Mr. Chairman. We have Jennifer Anderson.
Hi, good morning. You know me. My name is Jennifer Anderson, 3036 Coral Strip Parkway, Gulf Breeze. I've spoken here before. I'm not a citizen of the county, so thank you for allowing the public forum for non-residents to speak. I had a question. Given the number of complaints that are coming forward and the board's ability to hold special sessions, do you all intend to do that to hear the number of complaints that are before the board in a more timely manner?
Chair, if I could address that issue.
Go ahead.
During Board Secretary status report, that is something I'm going to be requesting of you.
Okay,
Okay.
thank you.
Thank you.
Thank you.
Any others?
Jacqueline Rogers?
Good morning, Board. My name is Jacqueline Rogers. I live in Escambia County. Just coincidentally, I know 2 people who were victims of one of the contractors today. I don't think that's a coincidence. I think that just goes to show you, and I didn't know until I started watching the meetings, and then I realized what's going on, and then someone said, oh, well, I'm a victim. And then someone else saw me speak at one of the public forums and said, I'm a victim. And so I really want to encourage you guys, you can't take any complaint just right off the bat. I understand that. But to act sooner, I watched the Santa Rosa County Board, and to me, it just seemed like now maybe they had the benefit of knowing this was going on with you guys. But, you know, there's a fence contractor in the news, and I don't know if that would fall under the purview of you, because he might not need to be licensed. But this is a very serious thing, especially with the amount of money some of these people are spending, their life savings. The one man that went to Alaska for 6 months and left his family so he could just fix his bathroom. I'm in a position where I need a contractor, and I need to know that if there are complaints, that you guys are taking these seriously. And I did see that last meeting. I'm not saying you're not. So, but I'm just encouraging you. This is really important to the citizens. Thank you very much.
Thank you.
There are no others.
No others? Okay, at this time, Board Secretary status report.
Yes, sir,
I'm
Chair.
gonna request a motion to move this item to the end, the item of the Sunshine Law presentation to the end of the meeting.
So moved.
Is the motion made second? Any discussion? Being none, all those in favor say aye.
Aye.
Opposed, like sign. It will be moved to the end of the presentation.
I also have a few items for you, sir, like we spoke about. I want to ask for a motion to approve a special session on September 21st. Because of the magnitude of the complaints coming to us, we really need to address some of those in a more timely fashion. So my request is for a special session on September 21st,
September
2020.
the 21st.
So moved.
Motion's made. Is there a second? Second. Motion made and second. Any further discussion? Being none, all those in favor say aye. Aye. Opposed, like sign. Being none, there will be a special session on September the 21st.
Yes, and just to clarify, that's in addition to the regular meeting on September 7th.
Okay.
Also, we have a request for an add-on for contractor license. Oh, I'm seeing it. Never mind on that one.
Okay, we'll move into item 7.
I got one more item.
One more item for you.
Yes, so because of what's been going on with this board and, just for public awareness of different items, the building official, Tim Tolbert, is doing an outreach program on August 25th, 2022 at 5 p.m. in this room for anybody that wants to attend. It's titled How to Protect Your Project. It'll teach you all you need to know about contractors, their license requirements. If you want to give any more details on that?
Oh, yeah, HBA is a part of it, and we have an attorney to answer questions and talk about contracts, and what they should look like, and, basically, information free-for-all, when you're trying to hire a contractor and, during your project, what to expect.
Very good. How are you gonna get the information out to the general public?
So we have worked through our CMR department to advertise on the radio, on the TV. We're also putting it on social media, and so,
Okay,
and letting you guys know.
thank you. Is that all for your report? All right, we'll move into item 7, number 1.
Item 7, number 1, contractor's license application, Davis Zieglerden. Did I say it right? Close. Okay. State your first and last name and address for the record, please.
Good morning, Board. My name is Davis Zaladon. I live in 89 Panago Road, East Hampton, New York.
Mr. Zeladon is coming for, was approved and recommendations for a general contractor.
Is there a motion made and seconded in the discussion? Being none, all those in favor say aye. Aye. Opposed, like sign. Being none, your application for examination, Mr. Davis Zeladon, is approved.
Thank you, Board.
Don't come back to see us.
Thank you, Chairman. The next applicant is Asa Hunt. State your first and last name for the record, Mr. Hunt.
Asa Hunt, 7050 Burlington Boulevard, Pensacola.
After reviewing Mr. Hunt's application, his recommendation for approval for a marine contractor.
Second.
Motion made and seconded. Any further discussion? Being none, all those in favor say aye.
Aye.
Opposed, like sign. Being none, your application for examination for marine contractor, Mr. Asa Hunt, is approved. Don't come back to see us.
The next applicant is Brad Sanders. Mr. Sanders, state your first and last name for the record, please.
Brad Sanders, 855 West Carroll Street, Dothan, Alabama.
After reviewing Mr. Brad Sanders' application, recommendation is for approval for, I think it's a sign erect, non-electrical
Yep.
contractor.
Motion to approve. Second.
Motion made and seconded. Any further discussion? Say again? Oh. Motion made and seconded. Any further discussion? Being none, all those in favor say aye. Opposed, like sign. Being none, the application for examination sign non-electrical for Mr. Bradley Sanders is approved. Thank you, Mr.
Thank you,
Sanders.
sir.
Don't come back to see us.
The next applicant is Josh Ditto. Mr. Joshua, if you could state your first and last name and address for the record, please.
Good morning, my name is Josh Dindo. My address is 250 North Jackson Street, Unit 2, Mobile, Alabama.
After reviewing his application, we recommend that he'll be approved for general contractor testing, sir.
Very good.
Motion to approve. Second.
Motion made and seconded. Any further discussion? Being none, all those in favor say aye. Opposed, like sign. Being none, the application for examination general contractor for Joshua Dindo is approved. Dindo, don't come back to see us. We got enough of that.
Thank you, sir. Our next applicant is Richard Carroll. State your first and last name for the record and your address, sir.
Richard Correll, 29 Fillmore Drive, Pensacola.
Mr. Correll is coming before the board for a reinstatement of a delinquent license. He was a pool contractor, took the test, we have all this, updated information. He paid the fee, he only owes us, $512.50, which he's able to make payment for today upon your approval, sir. Also, Mr. Richard, if you could explain to the board why you were in a delinquent status for so long, we appreciate it.
My wife was dying, to put it bluntly, and she wanted to be a part of the business as well, so I give her that part of the business for the insurance and license and stuff like that, to kind of keep her involved. Please don't think I'm selling her out, because I'm not. That was the best 30 years of my life. But things happened, and I didn't have a check and balance in position to make sure if something did happen, I would get to it. And that's how it fell through the crack, and it's my fault.
I understand, it was only about 4 years.
Yeah. She had several things wrong with her.
Yeah.
We just finally caught up with her.
Entertain a motion to approve.
Motion to approve. Second.
Motion made and seconded. Any further discussion? Being none, all those in favor say aye.
Aye.
Opposed, like sign. Being none, the request for reinstatement of license for Mr. Richard Correll is approved.
Thank you,
Mr.
gentlemen. Thank you.
Correll.
Thank you.
I'll get back with you. Thank you, Chairman. The next but the last is Mr. Don Hughes. State your first and last name for the record and your address, Mr. Hughes.
Good morning, my name's Don Hughes. Address is 3716 Juniper Circle, The Colony, Texas.
After the application's been reviewed, we recommend that he be approved for roofing testing, sir.
Motion to approve. Second.
Motion made and seconded. Any further discussion? Being none, all those in favor say aye.
Aye.
Opposed, like sign. Being none, the application for examination for roofing for Don Hughes is approved. Mr. Hughes, don't come back to see us.
Thank you.
Now we'll move into item 8.
Yes, sir, Mr. Chair. We'll move on to item 8.1, Matthew S. Banks, doing business as Banks Construction, LLC, state registered license number RR 282812001, contractor competency board complaint number 220679 COM. It's in regards to Trevor Gaiman, homeowner complainant at 3855 Kingsbury Drive in Pensacola, Florida. This is within the city limits. If you are here to provide testimony on this case, if you could please stand and be sworn in. Yes, sir.
Would you raise your right hand to be sworn? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
At this time, I'm going to turn it over to Melissa Reber, our investigator, to provide her investigation notes.
And Mr. Chairman, before we get started on it, I just want to verify that Mr. Downs still has the same.
Yes.
Is recused?
He needs to recuse for these, and I believe Mr. Lacoste's cases as well, based on.
That's
For
correct.
all of them?
Yes. And he obviously will fill out a form at the end of the meeting, but I just want to make sure that.
Yeah, and I did fill out the form for the last one. And then I would like to be recused from Lacoste and Banks.
Yes, sir. Thank you.
All of them?
Yeah, because that's the only two we have on here, right?
Yeah, well, what I'm saying, all of these?
Yes, yeah, all of them.
Okay.
Yes. Thank you, Mr. Chairman.
Thank you.
Good morning, Board. When reviewing this report, the county alleges these probable violations for this case. Code Section 1837D8, mismanagement or misconduct causing financial harm to a customer. Florida State Statute 489-129-1H as amended. Code Section 1837D9H, failure to supervise construction activities. Florida State Statute 489-1 1195 as amended, Code Section 1837D9J, failure to notify residential property owner of recovery fund, Florida Statute 489-119 as amended, and Code Section 1837D15C, proceeding on any job without obtaining applicable local building department permits and/or inspections, Florida State Statute 489-129-1P as amended. Job finished without a permit having been pulled, or no permit until caught after job, or late permit during the job resulting in missed inspection or inspections. Board, Escambia County Building Services received a formal complaint submitted by Trevor Guillaume in which he alleges that Matthew S. Banks, doing business as Banks Construction LLC, failed to commence contracted work on provided start date, failed to obtain permitting for contracted work, and failed to complete contracted work by the projected end date. Gingham's home is located at 3855 Kingsbury Drive in Pensacola, Florida. Gingham contracted with Banks on October 14, 2021 for a sunroom addition with a start date of December 15, 2021. The total cost for the work contained in the contract was $42,500. Contract did not contain the required clause informing Gingham of the Florida Homeowners Construction Recovery Fund. Gingham paid a 35% deposit of $14,875 and agreed to pay an additional $15,000 at work commencement. Gingham stated that work did not commence until March 16, 2022, and on that date, demolition of the aluminum roof of the existing patio was performed. Request was made by Banks on March 23, 2022 for an additional 15% for the construction project to continue. Gingham issued a check to Banks in the amount of $6,375. Gingham made several requests after payment for updates on work continuance. In April, demolition of the existing slab was completed and pouring of the new slab was performed. On April 22, 2022, Gingham notified Banks of possible deficiencies with the slab pour and requested clarification on whether the slab cuts were needed. Gingham received a response that slab cuts were required, but no projected date on when the correction would be performed. Gingham notified Banks via email on April 28, 2022 that he was terminating his contract with Banks, citing failure to perform, consistent delays, lack of communication, general mismanagement. Gingham stopped payment on the check for $6,375, which had not been deposited, and demanded a refund of his initial deposit minus the cost of the work already performed, which were documented with receipts. Gingham also stated that he would not pay for the failed concrete pour, which was not properly overseen. A review of the permitting history for Gingham's address resulted in no records being found for a sunroom addition permit pulled by Banks. Banks has not responded to any communication from Escambia County staff about this complaint.
Thank you.
Chair, Mr. Gaiman is present.
Mr. Gaiman? You want to come up?
I think she said it all.
She said it all?
Yeah.
Okay.
So, Chair, if you notice, we did something a little
Oh,
differently
yeah, you
this
put the
time.
alleged.
We went ahead and had that on the investigation notes for what we feel could be possible violations.
Given the information provided, and I'll entertain a motion to go to disciplinary hearing based on the alleged violations presented.
Do we need to restate these, or is it a part of the record?
Mr. Bell, you could simply make a motion to find probable cause for the alleged violations that staff has presented to the board today.
Thank you.
That's what I did.
Thank you. I think that would be sufficient.
Yeah.
Okay, I'll make a motion that we approve the alleged violations as presented and move forward to disciplinary hearing.
Is there a second?
Second.
Any discussion? Being none, all those in favor say aye. Being none, all those in favor, the motion is approved. We'll
Ne-
move to item number 2.
Yes, sir, Mr. Chair. This item is Jesse W. Lacoste, doing business as Lacoste Construction Group LLC, state registered license number RG 291103980, contractor competency board complaint number 220684 COM. It's in regard to Melissa Southard, homeowner complainant at 1425 East Mallory Street, Pensacola, Florida. This is also within the city limits. If you are here to provide testimony on this complaint, if you could please stand and be sworn in.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
At this time, Melissa is going to go ahead and present her investigation.
Board, we believe that after our investigations, the alleged violations are probable. Code Section 1837C1, disregard or failure to correct building code violations or any municipal or county building codes, ordinances, or laws of the state of Florida. 1837C12, violating any provision of this article. 1837D4, violation of state or local building codes or laws, Florida State Statute 489-129-1D as amended, Code Section 1837D10, abandonment, Florida Statute 489-129-1K as amended, Code Section 1837D12B, committing fraud or deceit in the practice of contracting, Florida State Statute 489-129-1M as amended, causing monetary or other harm to licensee, customer, or physical harm to any person. Code 1837D13C2, misconduct or incompetency in the practice of contracting as set forth in Florida Statute 489-129-1N, violation of any provision of Chapter 489, Part 1, Florida statutes as amended, 1837D13C, 3, misconduct or incompetency in the practice of contracting as set forth in Florida State Statute 489-129-1N, any other form of misconduct or incompetence. 1837D15A, proceeding on any job without obtaining applicable local building department permits and/or inspections. Florida State Statute 489-129-1P as amended, late permits, contractor pulls permits after the starting of the job but prior to completion of same and does not miss any inspections. 1837D15B, proceeding on any job without obtaining applicable local building department permits and/or inspections. Florida Statute 489-129-1P as amended, failure to obtain inspections. 1837D15C, proceeding on any job without obtaining applicable local building department permits and/or inspections. Florida Statute 489-129-1P as amended, job finished without a permit having been pulled or no permit until caught after job, or late permit during the job resulting in missed inspection or inspections. Board of Escambia County Building Services staff received a formal complaint submitted by Melissa Southard in which she alleges that Jesse W. Lacoste, doing business as Lacoste Construction Group LLC, failed to obtain permitting for contracted work within 30 days of receiving a deposit greater than 10%, failing to commence work in 90 days, and job abandonment for 90 days, failing to complete contracted work. Southard's home is located at 1425 East Mallory Street in Pensacola, Florida city limits. Southard's home sustained substantial damage in June of 2019 when a large tree fell on her home through the roof. Southard's insurance company sent out a remediation team almost immediately, securing the roof with a tarp. Southern contacted Lacoste Construction Group LLC and was given an estimate of $91,500 for insurance repairs. Just prior to the damage to the home, Southern had secured a home refinance loan with plans to do some renovation. Southern discussed these renovation plans with Lacoste, and he advised Southern he could do the renovation as well. Lacoste provided an estimate of $60,000 for the renovation work. Southern gave Lacoste a deposit of $45,028 on September 25th, 2019, which were proceeds she had received from her insurance. On October 4, 2019, Southern signed a contract with Lacoste for a total of $151,500, which included the insurance work and the additional renovation work. Southern also states she signed an assignment of benefits on this same day. The insurance company issued another check for $1,763 to Lacoste on 8/29/2019. Southern states that on December 26, 2019, she issued Lacoste a check for $21,914.95. Southern states that work began February of 2020 when the sunroom was demolished. Southern further states that no other work was performed until April 22, 2020. Lacoste was issued the final insurance disbursement on April 27, 2020 for $35,057.05. During April 2020, Southern states that very little work was performed and the work being done was building a covered porch. Southern states she elected to forego the damaged sunroom and just have a covered porch in that area. Southern states she questioned Lacoste why her room wasn't being replaced and said Lacoste told her he was still fighting with the insurance company over cost and just wanted to start something for her on the project. By September 2020, the only work that had been performed was a portion of the covered patio. Southern states that when Hurricane Sally hit, Lacoste contacted her and asked if she had sustained storm damage. Southern states that Lacoste recommended she work with a private adjuster, Noble's public adjuster, telling her they would be of greater help to her in the project than relying on her homeowner's adjustment. Southern states that when the adjuster came out, she was assured that they could get her hurricane damage claim settled and even offered to re-examine the tree claim to see if there was more things that could help her recover on that claim. Southern states that when Noble submitted the hurricane claim and the resubmission of the tree claim, her insurance put the roof on both claims, causing such confusion and a battle with her insurance company. Southern states that she spoke to Lacoste several times about the problems Nobles had caused with her insurance, telling him she wanted them fired. Southern states that Lacoste told her that he had nothing to do with Nobles and merely recommended them, and she chose to use them. Southern states by September 2020, she was constantly complaining to Lacoste about the lack of work going on and asked for a breakdown of how much money had been spent, but never received that information. Southern questioned Lacoste as to why her property hadn't even been dried in. Southern says that Lacoste told her due to the roof damage being reflected on both insurance claims, if he dried it in, he would have to tear it off to repair the damaged trusses, since neither claim had been regarding that work. Southern states that she sent Lacoste an email and a request through the Buildertrend construction portal asking that he let her out of the contract, remove himself from the insurance AOB, and give her her money back. Southern states that Lacoste has refused to do that. The only work performed with the $1,003,763 that Lacoste was paid has been a portion of a covered porch. Southern states she has had to endure several hours of EOU's testimony with her insurance carrier due to lack of work performed like Lacoste and inaccurate claim submission by Nobles. Southern says she has had to hire an attorney to bring a case against her insurance company. A review of the permitting history for Southern's address resulted in a demolition permit for a sunroom applied for on 2/13/20 but never issued. A permit issued on 6/29/2020 for a covered porch with a failed footing inspection and has since expired. A permit applied for renovations but never issued. Lacoste has not responded to any communication from Escambia County staff about this complaint.
Chair, Ms. Southard is here for any questions that you may have.
Do you have any? Thank you very much. Sorry you're having to go through this. Entertain a motion to take this to disciplinary hearing based on the alleged violations presented.
Motion to take this disciplinary hearings based on the alleged violations.
Is there a second?
Second.
Is there any further discussion? Being none, all those in favor say aye.
Aye.
Opposed, like sign. Being none, it's approved to send this to disciplinary hearing based on the alleged allegations as presented. Item number 3.
Yes, sir, Chair. This item is Jesse W. Lacoste doing business as Lacoste Construction Group LLC, state registered license number RG291103980, contractor competency board complaint number 220325. It's in regard to Christopher Schofield, homeowner complainant at 7828 Coronet Drive, Pensacola, Florida. If you are here to provide testimony on this item, if you could please stand and be sworn in.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
I'm going to hand it over to Melissa for her investigation report.
Board, we believe that our evidence will show alleged violations of 1837D8, mismanagement or misconduct causing financial harm to the customer, Florida State Statute 489-129-1H as amended, 1837D12B, committing fraud or deceit in the practice of contracting, Florida Statute 489-129-1M as amended, causing monetary or other harm to licensee's customer or physical harm to any person, 1837D15A, proceeding on any job without obtaining applicable local building department permits and/or inspections, Florida Statute 489-129-1P as amended, late permits, contractor pulls permits after starting job but prior to completion of same and does not miss any inspections. Board of Escambia County Building Services staff received a formal complaint submitted by Christopher Schofield in which he alleges that Jesse W. Lacoste, doing business as Lacoste Construction Group LLC, received funds from insurance claims related to Hurricane Sally and failed to start the work timely, communicate regarding cost, questionable billing by Lacoste for Schofield's home, submitted for payment to Schofield's insurance carrier, and failing to make any substantial repairs with the funds received. Schofield's home is located at 7828 Coronet Drive in Pensacola, Florida. Schofield's home was damaged by Hurricane Sally and again sustained roof damage by a tree company doing work for him in the aftermath of the storm. Schofield was advised to hire a general contractor to handle his hurricane repairs. Schofield contacted Lacoste, and after discussing the needed repairs, Schofield signed an assignment of benefits on December 4th, 2020, giving Lacoste control over Schofield's insurance proceeds, which were to be used to repair the home. Schofield states that Lacoste told him under the terms of the AOB, all insurance proceeds were to be given to Lacoste. On May 27th, 2021, Schofield issued a check to Lacoste for $20,576.39, which Schofield states were insurance proceeds. Schofield states he received a check from the tree company's insurance for $13,546.72 for damage caused when they dropped the tree on her home. Schofield states that he turned those funds over to Lacoste. Schofield states that over the next 6 months, the only actual work Lacoste performed on his property was having 3 tree stumps removed from his rear yard and board up 3 storm-damaged windows on his home with half-inch untreated plywood. Schofield states that on numerous occasions he requested that Lacoste provide him with an itemized estimate for the insurance repairs to his property and any paid invoices pertaining to the same. Schofield states that Lacoste refused. Schofield states that in June 2021, he received a letter from Comeback Restoration. The letter advised Schofield that a lien would be placed on his home if he didn't pay a $1,500 bill. Schofield states he spoke with the owner of Comeback Restoration, who advised him that the bill was unpaid for moisture mapping services ordered through Lacoste for their home. Schofield states that he reached out to Lacoste's office and was told to disregard that letter, that they were trying to get paid, and he would be paid when Lacoste received the funds from the insurance company for the moisture mapping services. On June 29, 2021, Comeback Restoration placed a lien on the Schofield's home. July 5, 2021, Schofield sent a certified letter to Lacoste advising them that he was rescinding the AOB due to Lacoste failing to have a substantial amount of work performed on his property. Schofield additionally requested copies of all paid invoices from monies that Lacoste had received from insurance proceeds. Schofield terminated the alteration permit obtained by Lacoste. A review of the permitting history for the Schofield's address resulted in roof permit issued to Sammy's Construction, Inc. on June 14, 2021 by Sammy's Construction for the roof, and an alteration permit issued to Lacoste on July 1, 2021. Lacoste has not responded to any communication from Escambia County staff about this complaint.
Chair, the Schofields are present.
Please.
Valerie Schofield, 7828 Garnet Drive.
Yeah.
In addition to what has already been presented, since then, we have hired an additional contractor who is able to complete, project within the means of the $68,000 that our insurance mailed to us. Jesse Lacoste attempted in July to reach out to our mortgage company and claim that he had completed the project and was owed the $68,049.89, to which our mortgage company contacted us immediately, stated he was not to get any funds, asked him for proof of funds or proof of completed work, which he did not provide. We terminated the contract, sent Jesse Lacoste a certified letter that we would be terminating contract with him. He did not get back with us. Since then, we have had so much going on with Jesse Lacoste. We got a roof. The roof, he bought so much stuff that we have enough supplies to roof another person's home. We have 14 packages of shingles. We have plywood. We have a whole garage full of materials that we're never going to use that we spent money on. This is so frustrating dealing with this. We spoke to an attorney trying to somewhat get any money back from Jesse. Jesse has not chose to speak to anybody, including our attorney. I don't know what else to tell you. It's just been a nightmare dealing with Jesse Lacoste.
He since filed a lien on our home.
You still have a lien?
Yes, from
He
both
filed a lien
comebacks.
saying that we owe an additional $34,000, and we have no idea what that's for. So now we have a lien on our home from Jesse Lacoste as well as Comeback Restoration. We spoke with the manager of Comeback Restoration, who said that Jesse Lacoste owes him $80,000 in past due bills, and he'd be willing to release our lien, and also work with us in order to try to help get our money back from Jesse Lacoste. But Jesse was, when we talked to our attorney last, was incarcerated, so we couldn't get a hold of him, or our attorney couldn't get a hold of him. So he contacted his criminal attorney, and Jesse agreed to sign a release of lien. But once he signed it, the attorney would never release it because they wanted us to sign a no harm clause that releases him from any type of money saying that he owes us. And we didn't sign that.
Who's that, Lacoste no harm clause, or the attorney?
Lacoste.
no-
Lacoste wanted a no harm
Okay.
clause. And, so at this point, we've signed over, what, $30-something thousand to him for work done, and the only thing that we have received was a roof on a 1,200 square foot house. No other work was completed. And now we have a lien on our home and a lien by Comeback Restoration. He actually falsified the amount of the Comeback Restorations project. He told our insurance company that was for over $1,800. When we got the bill ourselves from the Comeback, it was $1,500, and he said that he never issued him $1,800 check. We kept notes of everything and tracked it, and been working with Melissa, and we are just still trying to seek to get some of our money back. We're more than happy to pay for our roof that was done, but other than that, we don't understand where the other money went, or also why we have a lien on our home now for $34,000 and stopping us from doing anything with our home.
Well, you know where we go from here. You have to do to the disciplinary hearing, which is what we will do, and go from there.
But we just have been problem after problem, and
Just to add a little side note, the contractor that we were able to hire, which was Tommy Cody with Southern Ridge Homes, the moment that Tommy Cody and Southern Ridge Homes filed a motion or a lien to notice of commencement, Jesse Lacoste, as well as his office, contacted him and threatened him with legal action, saying that that was his project and that Tommy Cody and Southern Ridge Homes was not to proceed. To which we ended up referring him to our attorney, and he said to go ahead and continue the project, which that's the only reason that we were able to somewhat get our home complete.
Well, we'll moving forward, that's all we can do.
Okay,
We'll see what we do in disciplinary hearing.
okay, thank you.
thank you.
I'm sorry, I'm sure it's there, but just so you know, a lot of that information that the Schofield said, the liens and so forth, is in the backup
Yeah.
of the agenda.
Entertain a motion to take the disciplinary hearing to Lacoste.
Motion to take the disciplinary hearing based on the alleged violations submitted. Second.
Motion made and seconded. Any further discussion? Being none, all those in favor say aye.
Aye.
Opposed, like sign. Being none, the motion to take the disciplinary hearing for Jesse Lacoste with the Christopher Schofield complaint is approved.
All right, Chair. Our next
Hey,
item,
I have one thing I want to advise, the Nobles Public Adjusters. Have you filed a complaint against them? You can. They are licensed by the state, and you can file a complaint against them at the Department of Business and Professional Regulations. He's not under our control, but he is licensed by the state. Thank you.
Yes, sir, Chair. Our next item is Matthew S. Banks, doing business as Banks Construction LLC, state registered license number RR 282812001. Contractor Competency Board complaint number 220669 COM. It's in regard to Lori Jones, the homeowner complainant at 409 Bremen Avenue, Pensacola, Florida. If you are here to provide testimony on this case, if you could please stand and be sworn in.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Thank you.
At this time, Melissa will take over and relay her investigation report.
Board, we believe that what we present will show that Banks Construction is in violation of 1837C5, diversion of funds or property received for prosecution or completion of a particular construction project or operation by the contractor when, as a result of such diversion, the contractor is or will be unable to fulfill the terms of his obligations or contract. 1837D9J, failure to notify residential property owner of recovery fund, Florida State Statute 489-119 as amended. 1837D10, abandonment, Florida Statute 489-129-1K as amended. Code Section 1837D12B, committing fraud or deceit in the practice of contracting, Florida Statute 489-129-1M as amended, causing monetary or other harm to licensee, customer, or physical harm to any person. Code 1837D13C2, misconduct or incompetency in the practice of contracting as set forth in Florida Statute 489-129-1N, violation of any provision of Chapter 489, Part 1, Florida statutes as amended. Board of Escambia County Building Services staff received a formal complaint submitted by Lori Jones in which she alleged that Matthew S. Banks, doing business as Banks Construction LLC, failed to obtain permitting for contracted work within 30 days of receiving a deposit greater than 10%, failing to commence work in 90 days, and job abandonment for 90 days, failing to complete contracted work on Jones' home, contracted work. Jones' home is located at 409 Bremen Avenue, Pensacola, Florida. Jones contracted with Banks Construction for a kitchen remodel on May 11, 2021 for a total job cost of $42,350. Jones issued a check in the amount of $21,175 on May 11, 2021, representing a 50% deposit on the project. Jones and Banks project manager and designers began communicating about the project, design, material selection, etc. via email on May 14th, 2021, and continued for several months with on-site appointments being missed by Banks Construction staff. By December of 2021, Jones advised Banks that she wanted out of the contract and her money refunded with interest. These conversations continued into May 2022 when Banks agreed to have his staff cancel the contract and refund $21,175 in 2 payments. Also in May 2022, Jones filed a contractor complaint with DBPR, which she was referred to file a complaint with our department. Jones filed that complaint on June 2nd, 2022. Banks has not responded to any communication from Escambia County staff about the complaint.
Chair, Ms. Jones is present.
Please.
My name is Lori Jones, 409 Bremen Avenue, Pensacola, Florida, 32507. First order of business is I would like to apologize to you, Chairman of the Board, and the rest of the members of the Board for my anger and my animosity when I spoke in the public forum 2 months ago. I have followed all of the steps. I am trusting in this process. I wish Mr. Downs was still sitting here, because he would understand. That is Matt Banks' motto, trust the process, and I'm doing that with you guys. A couple of things I see wrong here. I did not sign the contract, my spouse did. Misogynism at its best. I was told, don't worry about it, as long as I get a signature, okay? I did not sign the contract, but I did sign the check, okay? I'm here on behalf of both my husband and myself, okay? That would have been about there in the third sentence of the synopsis, I believe. Mr. Jones signed the contract. Mrs. Jones signed the check, okay? Let's just want to clarify that. Now, where it says that he would have his staff here, where's that? He'd have his staff cancel the contract. Please read that email, somebody who's taken English, and tell me that that is what that said, because I didn't get it. That is not what I got from that email. And I tried to find that person, and I never was able to find her, okay? Outside of Facebook. All right. Now, I followed all the steps. I've gone through every single step that I've possibly been able to go through. And DBPR has my case again after they lost the paperwork the first time. I want to say I worked in the government up to the GS-12 level for 20 years, the federal government. I'm not a dummy, people. I understand what Matt Banks is doing here, and I understand what Banks Construction has done here. I also understand that my animosity is not going to make me get this money back. You all have a job to do, and I'm going to have to trust in you to do your job. I will also say to my people that I know Matt Banks has affected, and Jesse Lacoste too. I'm not leaving Jesse Lacoste or any of these other contractors out. I just want to say to y'all, they're men. They're human beings. And I don't rightly know that Matt Banks has done anything worse to me than the cumulative life I've lived in the past, okay? Whether it was by fault or by negligence. It's why I retired from the federal government. I had a job to do, and I could not depend upon other people to get it done, and I couldn't do it all myself. I have spoken to Matt Banks via text and email, not personally by phone, only because we're not, and I told him straight up, I'm no longer angry with you, Matt Banks. I never wanted to hurt his family, any of his family. I've apologized to him for my behavior, and I again apologize to you and to the public who will see this. I can be that person. I do not want to be that person, okay? I don't want to be that, and I will not be that person. I will not be allowed to be pushed into a corner again, but I will continue to work this process because I believe Matt is still doing this because he wants to prove to everybody he can. This is a character defect to me, and I believe that when he looks back one day and sees all this, it's going to make him a changed man. But you guys need to do your job to help me get there, and I'm praying for him every day, and I've been praying for y'all for 2 months. So I hope some good stuff's been coming around. The last thing I have to say, when I ask you all, I have to say this. It's said 2 ways. Yet I am confident I will see the Lord's goodness while I'm here in the land of the living. My favorite way is, I would have lost heart unless I had believed that I will see the Lord's goodness while I'm here in the land of the living. And to my friends and the rest of you, I want to say what God said to me about this. He knocked me down hard and said, wait patiently for the Lord. Be brave and courageous. Yeah, wait patiently for the Lord. God's going to get us, y'all. Only He can overcome evil. Thank you.
Entertain a motion to take it to disciplinary hearing.
Motion to move to disciplinary hearings based on the alleged violations presented by staff. Second.
Have a motion made and seconded. Any further discussion? Being none, all those in favor say aye.
Aye.
Opposed, like sign. Being none, the motion is approved to take this complaint to disciplinary hearing.
Thank
All right, Chair, our next item is Matthew S. Banks, doing business as Banks Construction LLC, state registered license number RR 282812001. Contractor Competency Board complaint number 220676COM. It's in regard to Russell and Janeth Bondurant, homeowner complainants at 2501 Sweetheart Lane, Pensacola, Florida. If you are here to provide testimony on this case, if you could please stand and be sworn in.
Yes, I'm here. Please raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Absolutely. Thank you.
Melissa, if you would like to go ahead and provide your investigation report.
Board, we believe will show alleged violations of 1837C5, diversion of funds or property received for prosecution or completion of a particular construction project or operation by the contractor when, as result of such diversion, the contractor is or will be unable to fulfill the terms of his obligation or contract. 1837D9J, failure to notify residential property owner of recovery fund, Florida Statute 489-119 as amended. And 1837D15A, proceeding on any job without obtaining applicable local building department permits and/or inspections, Florida Statute 489-129-1P as amended. Late payments, contractor pulls permit after starting job but prior to completion of same and does not miss any inspections. Escambia County Building Services staff received a formal complaint submitted by Russell and Janeth Bondurant in which she alleges that Matthew S. Banks, doing business as Banks Construction LLC, failed to commence contracted work on a provided start date, failed to obtain permitting for contracted work within 30 days of giving Banks a deposit greater than 10%, and failed to complete contracted work. Bondurant's home is located at 2501 Sweetheart Lane in Pensacola, Florida. Bondurant contracted with Banks Construction LLC on March 25th, 2020 for an 18 by 19 master bedroom addition renovation of the master closets and bathroom renovation of her galley kitchen, new flooring throughout the entire home, and interior painting of her 2,000 square foot home, excluding 2 guest bedrooms, with a start date of June 8th, 2020. The total cost of the work contained in the contract was $101,000. Contract did not contain the required clause informing the Bondurants of the Florida Homeowners Construction Recovery Fund. On March 25th, 2020, Bondurant paid a deposit of $48,000. Bondurant stated that the work did not commence until July 27th, 2020, and on that date, demolition of the master bedroom and bathroom began. Bondurant states that the demolition took 4 weeks to complete. August 2020, Bondurant states that the cement slab for the master bedroom addition was poured 3/4 of an inch too high. Bondurant states that the slab had to be leveled, and that didn't begin until January 2021 and took 3.5 weeks to complete. Bondurant states that she continuously questioned the lack of manpower on her project. Bondurant advised that throughout August, September, October, November, and December of 2020, there would be 1 worker present for an hour or 2 at a time, and then several days, and then sometimes weeks, no one would show up to work on the project. December 10, 2020, Bondurant states they were contacted by Banks Construction via email and advised that the renovation project was 50% complete, outlining the completed scope of work. The email stated that a draw of $25,350 was required in order to continue with the project. Bondurant states they complained to Banks that the project was not 50% complete. expressing the frustration with the length of time the project was taking and the inconveniences they have endured. The bondurants were told that without the requested draw, the project would not be able to move forward. December 11, 2020, bondurant issued a check for $25,350. Bondurant states they were contacted by banks in January 2021 and told to remove everything out of their kitchen, that the renovation would be starting in that area. Bondurant states it took 3 weeks to build a pantry. January 2021, the bondurants filed contractor complaint against Matthew S. Banks, doing business as Banks Construction, LLC, with the Department of Business and Professional Regulations, the Attorney General, Department of Agriculture, and Escambia County Building Services. On January 27, 2021, the bondurants emailed Matthew Banks requesting they be provided with a project completion date. The bondurants advised Banks that had prior family commitments coming over the next few months because they had believed the renovation would have already been completed in their home. The bondurant states that Banks never committed to a completion date. February 2021, Banks advised that they would be finishing up the electrical to the interior and get a material list for trim and order vinyl soffit, which the bondurant state was part of the 50% scope Banks claimed in December of 2020. April 3rd, 2021, Mr. Banks contacted the bondurants telling them he was placing the renovations on hold due to the fact that he had to gather all his paperwork to address the complaints against them they had filed. The bondurants state that for the next 2 weeks, nothing was done. April 21, 2020, having just been hired as a licensing investigator, I contacted the bondurants, advising them I would be investigating officer. Discussed the complaint and letting them know I would be reaching out to Matt Banks in order to obtain his response to the complaint. On the same day, I spoke with Matt Banks regarding the bondurant's complaint and stated that his contracts do not have a completion, date. However, acknowledging the project was behind schedule, stating manpower shortage, material delays in relation to COVID pandemic. Mr. Banks expressed frustration that the bondurants had filed several complaints against him. The investigation was assigned a complaint number 210431-COM. I spoke again with both parties on May 6, 2021, and they seemed to agree that the project might be back on track. The bondurants advised they had a new project manager with Banks, and although still frustrating, having their home under renovation for almost a year, they felt as if the project may be slowly moving forward. Mr. Banks advised that he was committed to seeing the project, telling his team the bondurants were a top priority. September 10, 2021, my case notes indicate that I confirmed that all applicable permits were still active. October 2021, spoke again with both parties and met with the bondurants on site. At this time, the addition master bedroom bath was complete, and the bondurants were relieved they had that space back. They remained frustrated that the rest of the renovation wasn't progressing. Their kitchen was still emptied out from January, and the only work that had been completed was the pantry. Mr. Banks advised me that he wasn't going to finish the project. He stated the working relationship had deteriorated. He felt the bondurants had been provided in full the scope they had paid for up to this point, $73,350. The alteration permit was still active and inspections successfully conducted up to that point. The remainder of the scope was work that did not require permits, and the bondurants had still not terminated the contract. Staff concluded that there was not sufficient evidence to move the case forward to a probable cause hearing. Both parties were advised that this investigation would be closed. June 1, 2022, at the contractor competency hearing, Ms. Bondurant speaking at public forum asked the CCB to request staff to review her complaint again for probable cause. Ms. Bondurant completed another complaint form and some additional documentation outlining specific costs and expenses occurred during her renovation. A new case was open and all documentation reviewed again. A review of the permitting history for Bondurant's address shows that on June 16th, 2020, Banks obtained an alteration permit. August 4, 2020, an electrical permit was issued and passed for a standalone on August 5th, 2020. November 4, 2020, a plumbing permit was issued. November 6, 2020, a gas permit was issued. And November 19, 2020, an electrical permit was issued. It was determined that a permit was never obtained for the master bedroom roof addition. Speaking with a license holder for the roofing company, he thought the number of squares installed fell under the guidelines of not requiring a permit. June 10, 2021, Banks reinstated the alteration permit. On July 6, 2021, an after-the-fact roof permit was obtained and a final conducted on July 23, 2021. Banks has not responded to any communication from Escambia County about this new complaint.
Ms. Bondurant is present, Chair.
Please.
Good morning, everyone. My name is Jan F. Bondurant. I live at 2501 Sweetheart Lane, Pensacola, 32526. And I also wanted to include that on July 9th, 2021, I requested a sworn statement of account from Banks. And on 17 July 2021, Mr. Banks replied with the nature of services performed to date to include a master bedroom addition and full renovation of the master suite at a cost of $76,000 from us thus far. Due to the constant rework and delays, the master area could not have been completed on 17 July, as he indicated in the sworn statement, due to the fact that he contracted a cleaning service which completed the cleaning of the master suite the week of September 23rd, 2021. Also in the sworn statement of account, the nature of services to be performed, a complete kitchen reno, new exterior door, new flooring and interior painting throughout the entire home, and a remaining balance of $25,350 per our contract. In July 2021, Jacob instructed us to remove everything from our kitchen because they were going to begin reno of that kitchen. It wasn't until February 2021 when smoke began demo on the wall for the pantry. When he finished, I asked him about installing the floors and baseboard and sealing the wall next to the stove. He said that when they do the reno of the kitchen, that's when the floors and baseboards will go in. For 8 months, drywall and wires were exposed next to our stove until October 2021. That's when we finally found a company to reno our home because no one wanted to complete another contractor's project. In September 2021, Mr. Banks still could not give us an overall end date or start date as to when his company would begin the renovation on our kitchen, floors, and painting. For 15 months, we were still living in a constant war zone while Banks was still accepting new clients' contracts and granted new permits, which we were still undergoing delays and excuses. Mr. Banks left a hole in our wall in our kitchen next to our stove. He never came back to inspect the subpar quality of work by his crew. And in doing so, the painting work that they did, the paint started bleeding through the light fixtures in our bathroom, and the pocket doors are scraping because Smoke said that the workers used 5-inch nails instead of 2-inch nails in the shiplap. Because Banks Construction walked off and did not complete the remaining items on our contract, we had to hire 3 additional companies to renovate the entire kitchen, entire flooring throughout the house, and interior painting at a cost of $38,500, which was $13,150 over our contract with Banks, and which is the amount that I'm seeking restitution. I also have pictures, which I'm sure you have, of how Banks left our kitchen. This entire side of our kitchen is open and exposed next to our stove. And as you can see, our floor is just a cement slab. This is how he left our home and never came back to fix anything. He and his cousin, whatever his, LaCosta, they are the worst. I reached out to him not knowing that they were related, this LaCosta, and he wanted to charge me $44,000 just to finish my kitchen. They should be under the jail. I'm not as nice as the other lady. I hope everything that they did to all these other clients come back on them threefold. Thank you.
Thank you. Entertain a motion to take it to disciplinary hearing.
Motion to move to disciplinary hearing based on the alleged violations presented by staff.
Second.
Motion made and seconded. Any further discussion? Being none, all those in favor say aye.
Aye.
Opposed, like sign. Motion to take it to disciplinary hearing is approved.
Chair, our next item is Matthew S. Banks, doing business as Banks Construction LLC, state registered license number RR2828120001, contractor competency board complaint number 220678, COM. It's in regard to Christopher Welch, homeowner complainant at 4027 Erica Court, Pensacola, Florida. If you are here to provide testimony on this complaint, if you could please stand and be sworn in. Thank you.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Melissa is going to relay her investigation report.
Board, we believe the alleged violations in this case will be 1837C5, diversion of funds or property received for prosecution or completion of a particular construction project or operation by the contractor, when as a result of such diversion, the contractor is or will be unable to fulfill the terms of his obligation or contract. Code Section 1837D8, mismanagement or misconduct causing financial harm to the customer, Florida Statute 489, 129(1)H as amended. Code Section 1837D9H, failure to supervise construction activities, Florida Statute 489, 1195 as amended. Code Section 1837D9J, failure to notify residential property owner of recovery fund, Florida Statute 489, 119 as amended. Code Section 1837D15C, proceeding on any job without obtaining applicable local building department permits and/or inspections, Florida Statute 489, 129, 1P as amended. Job finished without a permit having been pulled, or no permit until caught after the job, or late permit during the job resulting in missed inspections or inspections. Escambia County Building Services staff received a formal complaint submitted by Christopher Welch in which he alleges that Matthew S. Banks, doing business as Banks Construction LLC, failed to commence work, failed to obtain permitting for contracted work, and failed to complete contracted work by the projected end date. Welch's home is located at 4027 Erica Court in Pensacola, Florida. Welch contracted with Banks on August 17th, 2021 for an addition. The total cost of the work contained in the contract was $76,200. Contract did not contain the required clause informing Welch of the Florida Homeowners Construction Recovery Fund. Welch paid a 33% deposit of $25,400 on August 18, 2021. On November 5th, 2021, Welch received a letter of a UCC lien notice from ABF Servicing, who represents Pearl Delta Funding, a creditor of Matthew S. Banks and Banks Construction. The letter advised Welch that Banks had a balance due of $122,756. The letter suggested a lien could be filed against Welch's property if Welch did not forward any outstanding funds due to Banks on their project. Welch reached out to Banks about the letter, and Banks responded to disregard that notice as it was irrelevant to his company. Welch stated that work did not commence until November 11th, 2021. Welch advises that there were numerous times they were advised work would begin and then no one would call or show up to the property from Banks Construction. Welch states on April 12th, 2020, a voicemail was received from a representative of ABF Servicing following up on the UCC lien notice previously received about the outstanding merchant debt of Banks. Welch reached out to Banks, and on April 13th, Jared Kendrick, project manager for Banks Construction, responded saying this was an issue prior to Welch becoming a client and that no materials were purchased for their project from that company. Therefore, Welch could not be held liable for the payments. Kendrick additionally stated that until another payment was made, he could not have work performed on Welch's project because there were no more funds in their billed account. Banks also responded that the matter with the creditor had already been settled by his attorney and had no bearing on his company. Welch responded that an official statement of their account was needed. Kendrick responded he would bring the paperwork that afternoon showing where the project funds were spent, but he would need to pick up a check so he could pay the workers who would be due to show up. Welch responded that no one had showed up the previous week or that day. Welch received a cost breakdown from Banks showing that $22,851.44 was spent on the project. Welch stated paid invoices were requested but never received. May 19th, 2022, Welch's attorney, Ryan Halter, sent a certified letter of contract termination and demand for return of construction funds. Halter states that a generously estimated amount of funds spent on the project was $6,500. Therefore, Banks should return $18,900, which is an estimate of the unearned construction funds. Halter stated that the funds be payable to the law firm no later than close of business on June 3rd, 2022. The letter was received by Banks Construction on May 23rd, 2022. A review of permitting history for Welch's address resulted in permit 22012844BD issued on January 26, 2022 for a residential addition, and that permit terminated on June 22nd, 2022. Banks has not responded to any communication from Escambia County staff about this complaint.
Mr. Welch?
He's coming.
Good morning, everybody. How are y'all doing?
Good.
So we had got a new contractor, Reese Construction, and we had them to come out and look at the site and property so he can give us a breakdown of what Mr. Banks had done. So he said that what they had done was so far was considered to be like $4,550. We looked at it, and he looked into Mr. Banks that they had ordered new trust. So we said, well, let's make sure that he didn't order the trust. So Mr. Reese reached out to the 3 trust companies there in Pensacola. No trusts were built. So once again, that was on the, I guess the invoice. He said, he ordered trust for us, but there's no trust. So, I'm just saying, Mr. Banks, trust the process? No, don't trust this process. But so far that's all I have to add to the what he said though. But yes, sir.
Did your attorney receive a check?
From us? Yes.
No, from Mr. Banks?
No, he has not received a check from Mr. Banks.
Because he was told to send him a check.
No, there's no check been sent.
Okay.
No, sir. We have not received a check from Mr. Hadley would have informed us. No, sir, we have not received any check from Mr. Banks at all.
Okay. Any other questions? Thank you.
Thank you.
Entertain a motion to send it to disciplinary hearing.
Motion to send a disciplinary hearing based on alleged violations presented by staff.
Second.
Motion made and seconded. Any further discussion? Being none, all those in favor say aye. Opposed, like sign. Being none, the motion to send it to disciplinary hearing is approved.
All right, Chair, our last item in probable cause today is Jesse W. Lacoste, doing business as Lacoste Construction Group LLC, state registered license number RG 291103980, contractor competency board complaint number 220685. It's in regard to Thomas and Bonnie Chanteau, homeowner complainants at 6009 Shandell Circle in Pensacola, Florida. If you are here to provide testimony for this case, can you please stand and be sworn in?
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. Thank you.
At this time, Melissa will relay her investigation.
We believe the alleged violations in this case is 1837D8, mismanagement or misconduct causing financial harm to the customer, Florida Statute 489, 129-1H as amended. 1837D12B, committing fraud or deceit in the practice of contracting, Florida Statute 489, 129-1M as amended, causing monetary or other harm to licensee, customer, or physical harm to any person. Escambia County Building Services staff received a formal complaint submitted by Thomas and Bonnie Chanteau, in which he alleged that Jesse W. Lacoste, doing business as Lacoste Construction Group LLC, received funds from insurance claims related to Hurricane Sally and failed to start the work timely. Communication regarding cost, questionable billing by Lacoste for Chanteau's home, submitted for payment to Chanteau's insurance company, and failing to make any substantial repairs with the funds received. Chanteau's home is located at 6009 Shandell Circle in Pensacola, Florida. Chanteau's home was damaged by Hurricane Sally. Chanteau signed an assignment of benefits giving Lacoste control over Chanteau's insurance proceeds, which were to be used for the repair of the home. Chanteau contracted and paid for a new roof with Southeast Roofing. Chanteau states that Lacoste sought and received payment for the roof, according to his insurance company. Chanteau states that Bobby Dawson, project manager with Lacoste Construction, performed an inspection on his property and submitted to Chanteau's insurance company. Chanteau states that he issued 2 payments directly to Bobby Dawson for a total of $2,500. Lacoste would later try and collect those funds from Chanteau. Chanteau states that Lacoste sent one employee out for about a week to mud over the insulation and drywall work, which Chanteau states he purchased and installed himself. The insulation and drywall, Chanteau states that due to no work being formed, he threatened to get a lawyer, and Lacoste sent another worker out to begin tearing out the flooring, however never finished. No one has ever been back to perform the work. Chanteau states that he purchased materials and has continued to do the repairs on his home. Chanteau contacted his insurance company about the status of insurance proceeds and was told that the proceeds had been paid in full to Lacoste, and that they would have to settle the matter between Chanteau and Lacoste. Chanteau filed a contractor complaint on June 8th, 2022. Lacoste has not responded to any communication from Escambia County staff at this to this complaint.
Thank you. Madam Secretary, would you go back to the alleged violations?
Yes.
I believe an alleged violation would be he didn't obtain a permit.
We can add that, sir. That alleged violation would be 1837D15C.
Yep.
Job finished without a permit having been pulled.
Yes,
Or-
please
Well,
add.
he didn't finish any job. He never,
He didn't pull a permit.
he didn't pull a permit.
Or perform any work that required.
Well, how about,
permit.
1837D15?
Without this subcategory?
Yes.
Okay. 1837.
Please add that.
Okay.
Entertain a motion to take the disciplinary hearing.
Board,
What?
if,
The
I'm sorry.
Shintos are both present.
Oh,
Yes.
They had some additional documentation they were able to get.
okay.
Good morning, folks. Trying not to take up much of your all's time this morning. I'd like to spend this 3 minutes that I have to go over this timeline for one thing, shows fraud and negligence and everything else that you looked up for us, and I appreciate that. And I'm sure there's several other incidents in these documents as well. Hurricane Sally happened on 9/16/20. We're all aware of that. I called Citizens Insurance that morning. They sent an adjuster out, Robert Hanson. He was very fast. He did a walkthrough. He made an adjustment. We got an initial check to get our roof and fence going because it was leveled. They sent a check to Bonnie and I for $28,391.84 in both of our name, obviously. On 9/27, we contracted and paid Southeast Roofing, who's separate from Lacoste, okay? We did that ourselves. Our deductible came out of that. We paid our deductible of $7,500 on top of that to have our roof repaired. And then myself and my neighbors, we fixed our fence with the help of another company, Green and Green. Had nothing to do with Lacoste Construction or those guys. On 11/16, Comeback Restoration, who we somehow got in contact with through a friend of a friend. They had been out. They came out and did the tear out parts of where the roof had been damaged from a storm, where a tree hit the roof, water had came in, damaged the floor, damaged the roof. They came and tore all the ceiling parts out, leaving holes in the ceiling.
Or an entire wall.
An entire front wall of the house. I've got pictures and videos of all this, by the way. So they did their part of tearing that out. So I'm assuming, hopefully, that they got their money prior to Lacoste, because they're the ones that gave us Lacoste's name. Because we were like, okay, now the tear out's been done, now we need somebody to fix it, which is what the initial guy, Robert Hanson, when they cut us this check, they said, now you're gonna have to go back for supplemental funds to get these repairs made. We're giving you enough to get started. Somebody will come back in and do this, which Lacoste Construction is who we ended up getting a name from Comeback Restoration. We got in contact with them. We reluctantly signed a contract with Jesse Lacoste on 12/19/20. Jesse signed that contract on 12/23. That was done through DocuSign, and Melissa has a copy of that. Let's see, and not sure at this point. It appears that they may have gotten a check up front at that point as a portion to get things started with, I guess, to get work going. The weather had started turning cold. We realized that we probably weren't going to get anything done, so I covered those holes in the ceilings myself with plastic at first, and then as the summer went on, got closer to summer, because we still had
a whole wall empty and, just out.
So I went and I bought
That's the
sheetrock,
studs.
GFI breakers, screws, you name it, I bought it. So I had done sheetrock in the past, so I fixed all of those holes throughout the house, the walls, everything.
Put insulation in.
Put insulation in, the whole nine. Now we have no permit on our property anywhere up to this point, so I'm assuming they never pulled a permit. I don't know that for sure. So like I said, it was getting warm, so I went ahead and did those things. I also tore up carpet in the back area of the house in a couple bedrooms. Got that out of there, because again, they had not done any of that at this time. Just giving me excuses, kind of run around. on 10/1/25, Bobby and I'm sorry, 10/1/21, Bobby and I kind of got into a text argument, Bobby being his foreman or whatever he was, because there was also a guy, Gene, that was the foreman. Bobby was like the super or something. We got in a kind of a text argument. I told him I was going to call the insurance investigator, which was the claim handler, Valerie McDonald. He says, okay, go for it. And this is in quotes. Okay, go for it. I will have our stuff in tomorrow. So, and he did, which would have been for the second payment, I'm certain. After several phone arguments, calling the office to never get past the secretary, I told her they could talk to legal, meaning the secretary. Bobby called me straight back, this time hounding me that he needed another appraisal that we have to pay for, which is what she was talking about, the $2,500. That we wouldn't have to worry about it. We'd be reimbursed with that in cash at the final, but that had to be paid up front, and that's something we would have to endure. Told him I did not trust that, and I felt like there was but we were at no choice at that point. I had Bonnie write him a check for $1,000 because I wasn't going to give him the whole $2,500.
And we had to pay directly to Bobby.
That we paid directly to Bobby, and I have pictures of those checks. With the caveat that I would give him another $1,500 check that she wrote.
But they picked the guy.
Once things got going, when we finally could get some results that we'd give him the other check on 6/10/21, that check was made to Bobby Dawson by his request in his name. Second check on 6/15 made to Bobby Dawson by request. After I was calling their phones, they sent out a single guy. His name was Rusty. Seemed to be a very nice guy. Didn't move too fast. Used a lot of my tools because he didn't really have a whole lot with him. Oddly. This guy, Gene, brought him out, gave him directions when he would drop him off in the day because he didn't have a vehicle. He would drop him off. He would tell him what to do and how to do it. And super nice guy, though. We would buy him lunch, because she was working at home at the time.
They used our paint.
They used our paint from where we had just had our house completed being painted, because we had just bought it several months before the storm. It had just finished the week, like 3 days before the hurricane. The guy finished
But
painting.
at that point, it's year-old paint because it took them a year
to
get all this completed.
After several attempts to try to get Valerie, which is the insurance person, I get through it. She breaks it down and says, we're not paying any more to them. We've paid a bunch. I said, don't you want your lawyers to talk to these folks? She said, it's your money now. We don't mess with it after it's paid. You'll have to deal with it. So we basically kind of gave up again. And then finally, I reached back out to them and just told them, hey, you know what? We're not dealing with you guys anymore. You need to get your legal people to get with our legal people and have a meeting. I actually got an immediate response out of Bobby on that, and he said, Mr. Shanto, we have your floor at ProSource, which is where they had already sent us 3 or 4 times to look at floor, because each time we would go there, they're like, oh no, that's too expensive. Oh no, you got to do this cheap snapping floor. We had beautiful hardwood floors. So they sent another guy out to start tearing up the floor, right? So they worked for a day and a half, and they're not getting paid, so they left. Now, and I have pictures of all this, our floor is left with concrete, with glue, and wood shards sticking up. So Bonnie and I had to tear out the rest of the entire floor ourselves, clean up the subfloor. We went and bought flooring ourselves and started putting it down, which does not look like what a contractor, I'm certain, would do. I would hope not, because I'm obviously a terrible contractor, But we do have a floor now. It's not concrete, sorta. It's almost
not wood
it's
shards.
not
I'm
done.
not getting splinters when I walk on
No.
it now.
So at any rate, and I'm not trying to take up all your time with jokes or anything, when I went back to ProSource, because I said, these guys said the floor was here. If that floor is here, I want it, And they said, we canceled all their accounts because they weren't paying. So I called because they had.
So they never even ordered our floor.
They never even ordered the floor when they said it was actually there. So I called the dumpster guy, because the dumpster is sitting in our driveway at this time, and I said, hey, you know, how do I get in contact with these people? And he said, I'm pulling that dumpster out of there tomorrow. I'm pulling them from all their job sites because they haven't paid us. We're in the rears. So then I started contacting Bobby and Bobby and Gene and first said, I don't work there anymore. They let me go a couple days ago. And then Bobby said the same thing. He said, we're mad. They let us go a few days ago. Whether that's true or not, I don't know. So that's kind of where we're at, but I think that implicates Bobby also in this fraud from insurance. And, you know, the final to the insurance, from the insurance company, the final check that was given to them was, without looking at it specific, was $36,000 some dollars. Oh, here we go. The total payout to, that Bobby Dawson signed for, the total award was $64,320.06. Now, I did all this work myself, so who are they paying me? You know, I mean, this guy came and did some mudding and painted. I mean, you know, I mean, so, and plus, I went and bought all the hardware, all the lights, everything, because they said, you go ahead and buy it, we'll replace it. You know, we'll pay you back, basically. I gave all those receipts to Gene. Nothing, okay? Had asked them for it. They're like, he's like, get with Bobby. Bobby's like, get with Jesse. Jesse, I saw one time, that was when him and Bobby first came out and walked through and promised all these things and said, we're gonna do all this, all this, all this. So I was hounding them and I said, I wanna see a list of what you're doing. I wanna see a list of what you're billing for. So he finally agreed to get that $2,500. I'll bring it over and drop it off, but I need you to sign something. So what he brought over was a completion of contract. They hadn't done anything yet. She's home at work, I'm at work. So when they brought that in and gave it to her, it was like, I need you to sign this and then, you know, I'll get this stuff done. So to get that $2,500 check. So she signs it. It says that they're all done with everything, but I can show you, I'm still working on this floor. It's not done. So, you know, but they fraudulently put that they had completed this job with all this stuff. And what I'm looking at on it, it looks like they may have even possibly billed for another roof when Southeast Roofing did the roof and I paid them. So, I mean, you tell me.
Okay. We'll do what we can do.
I appreciate it. Thank you.
Thank you for being here. Hate you having to go through it.
I appreciate it.
Motion to send to disciplinary hearings for the alleged violations as stated, plus the additional violation.
Second.
1837 D15.
Yep. Second. Motion made and seconded. Any further discussion? Being none, all those in favor say aye. Aye. Opposed, like sign. Being none, the motion to send it to disciplinary hearing is approved for the Lacoste complaint. And we're through section 8. We're through section 8.
Yes, sir, Chair. We'll now circle back to the sunshine law presentation. Miss Christy Hankins has already introduced herself to some of you. She will be our new Assistant County Attorney.
Before she does this, what's the status of the 30 days on
Oh.
banks, please?
Yes, sir, Chair. So for Banks and Lacoste, at
Yeah,
our
both
last
of them.
board meeting, there was an order for restitution. And if they failed to pay that restitution within 30 days, that their licenses would be revoked. That end of time period will be on August 10th. So on August 11th, we will make contact with both complainants in those cases and find out whether restitution was made. At that time, based on the board's decision, we will take action on the
Okay.
license.
Very good. Thank you. You're on.
There we go. Thank you. I'm Christy Hankins. I'm an assistant county attorney.
Excuse me just a minute. The rest of you can go if you want to. You don't have to stick around for this.
Not that it won't be fun.
It'll be boring.
Hey, easy peasy over there.
The subject matter.
Yeah, well, okay. Yes, sir. Somebody's raising their hand in the back.
May I ask a quick question?
Yeah.
Yes, absolutely. My name is David Bryan, 2725 Blackwood Drive, Cantonment, Florida. Obviously, you're beginning to see the scope of what we have here with banks and Lacoste. And it's much bigger than is even being presented. This is growing leaps and bounds.
Oh,
There's
yeah.
well over 100. The recovery fund is something that we are trying to, I think a lot of people are interested in trying to figure this out. And it's a lot of legalese, and none of us are lawyers and attorneys. Even the restitution, people who are getting restitution, like you just mentioned a little while ago, ours will be up next month to see if restitution will be granted. We have questions. We don't even know exactly where to go to ask questions as far as restitution. Is it dischargeable in a bankruptcy if he bankrupts?
We're not lawyers.
Okay, so
Mr. Chairman, a good place would be the 25th when we have that workshop.
great.
That's
Yeah,
what-
I've already
Yes.
marked that down.
That would be it. There's an attorney will be present to answer all those questions.
Gotcha.
And also, it does say within the statutes for the recovery fund that an order for restitution could be used to access those funds. We are currently researching if that is an order from this board, could that be utilized, or if it's only orders from the CILB. So we're in the process of researching that.
Okay, yeah, we were actually looking as well through a court. It's small claims for us. Others, of course, is nowhere near small claims. Garnishment, liens on properties, which he's selling as fast as he possibly can, Matt. So terrific. We look forward to being at the next meeting and hopefully get some information. Thank you
Very good.
again for
Surely.
taking all of this very seriously, and it is growing, so. And I'm sure your presentation is awesome.
Thank you so much.
I have one more question, I'm sorry, and then I'll be quiet and you can present on that.
That's okay.
Quick question. Say your name again, please.
Yes. Jennifer Anderson, 3036 Coral Strip Parkway, Gulf Breeze. My question is around the recusal form that Mr. Downs put in the materials, the background materials this morning. I've never seen that before. I don't know if it's necessary for recusal. I don't know if he's been on the board previously during Matt Banks's or Lacoste hearings. But I noticed that it was backdated to November 16th without a year. And also that it doesn't have a file date. So I just want to make sure that, obviously as the board, you're aware of the personal connection, but also the perception to the citizens, right? That he may have participated or influenced in some way some of these hearings. So I just wanted to note those discrepancies on the form. And, also, maybe somebody should advise him that he should get better friends, but that's just a personal opinion. I'll leave now. Thank you.
Rest assured, he has had no input. Now then, you may proceed.
Now then, I'm Christy Hankins. I'm an assistant county attorney with the Escambia County Attorney's Office. The presentation today is on the Sunshine Law. I hope it's a little bit more interesting than you anticipated. The first slide is a picture of what was called the pork chop gang for 1956. This is pulled from historical documents for the state of Florida. We're not sure where that name came from, but they were dubbed that name. This is 20 Democratic representatives in the state of Florida, for the state of Florida in the legislature, and they were dubbed that by the press. So we're not sure where the press came up with that or why they chose it. Maybe it was what they eat, or maybe it was the amount of pork that we're putting in bills. So, but we don't know. So what had happened previously, you can go on to the next slide. What was going on in the state legislature was that there was a lot of deals being made outside of the presence of the people, and they were not being made in a setting where people could be heard or could see what was happening. Poker games, fishing trips, hunting grounds, deals were being made, and the majority of Florida.
That's the pork.
against the board. And the there was a large number of Floridians that are in South Florida that weren't being represented properly within the legislature. And the northern region had control over most of the decisions that were being made because of these 20 individuals. There was a representative by the name of Emory Cross who pushed through the Sunshine Law. He gave himself his own nickname of Red Cross because he didn't want anyone else to give him a nickname. Emory Cross started trying to put the Sunshine Law as we know it through in the 1950s. He fought for 10 years to get it there. And it kept getting shot down. Of course, it wasn't getting out of committee with this particular group in charge. Then in 1967, the Supreme Court ordered reapportionment throughout Florida to give representation to all the people of the state of Florida. And so as you can imagine, when everyone gets represented, then the appearance of our legislature changed. With the change in that appearance, Emory Cross was able to get through the Sunshine Law as you know it now, and it is found at 286.011. Prior to that, there had been a Sunshine Law that was passed in 1905, but it only pertained to when the entire group was together. As time has progressed, and as the courts have become involved in interpreting the legislation, it came down to changing the interpretation to say it means that any time there are two or more of any representatives on a board, any two or more people from a board together, that information is subject to Sunshine Law. And that's why you're not supposed to text each other, you're not supposed to call each other, you're not supposed to talk about the business that this board discusses outside of the presence of the public. So that's where that came from. One of the interesting things that I came across as I was preparing this presentation, among the things that occurred, was probably one of the most positive things that came out of that group of legislatures. It came from a poker game. And you may be familiar with, I'm looking for his name in my notes. I know you're familiar with the Everglades. And the Everglades actually came out of a poker game with some of these members of the legislature at the time. It was, you've heard of John Pennekamp. He was he was editor of the Miami Herald back in the 1940s. He was an environmentalist and had sought to protect the Everglades, but he couldn't come up with the funds to do it. Originally, he needed $400,000. He got into a game with some of the legislators, a poker game that he couldn't lose, and he just kept hitting and just kept winning. And the question was finally put to him, how much money do you need? We'll give it to you from the legislature. Just quit taking it out of our pockets. They gave him $2 million at his request. And he was able to purchase the Everglades and put it into national protection. So when I talk about backdoor deals, there were some big ones. And that was based on a conversation that was recorded, that was taken by the legislature's clerk. So that was his statements that he told to the legislative clerk. So these are the things that have come since that time, based on new laws, amendments to those laws, additional laws. And this is what we have to remember. The meetings have to be open to the public. And as explained, anytime two or more of you are gathered together, it has to be open to the public, and you should not be discussing business that's going to be before the board. That's a little hard for us at times because it's our nature to reach out to someone and go, what do you think about this? And to get input from each other. But we have to resist that urge as a public board. There also has to be reasonable notice to the people, and minutes must be taken and promptly recorded. As you see here, all meetings of any board or commission of any state agency or authority, or of any agency or authority of any county, municipal, corporation, or political subdivision. In 1971, the Burns Florida Supreme Court is where the language came from, any two or more members. And they said that this could apply to less than quorum meetings. So that's where it started expanding in 1970. There's also a requirement that the board provide reasonable notice of all such meetings. Of course, how can your public be there to offer input if they don't know what's going on? So it allows people to come forward and offer information and to give the board items of interest and maybe information that you wouldn't have otherwise. It also allows the people who are our bosses and who provide for us to exist. It allows them a chance to be heard and to have input on the things that affect them. Then the minutes of the meeting or any such board or commission have to be promptly recorded and made open to public inspection. There are exceptions, and we'll get into some of this. You'll note that in 2013 was the passage of the reasonable opportunity to be heard, where they have to be given reasonable opportunity to be heard on a proposition before the board or commission. That language on a proposition is important for your understanding, because that means that not everything is open for public comment. And not everything is necessarily open to the public. However, it does have to be recorded. The opportunity to be heard includes, it doesn't have to occur at the same setting of the official action. It does have to be during the decision-making process. And you'll see that I capitalized on the next slide. Reasonable proximity and time before official action, which it wouldn't do us any good if it was after the official action. And it doesn't prohibit orderly conduct and proper decorum. I thought that was interesting, and I thought it was going to get a little heated in here today, so I thought that was interesting when, as I watched the proceedings. If we can move on to the next slide. So there we have the opportunity to be heard, and we can move on to the exceptions. The exceptions, as listed here, include emergency affecting public health, where an unreasonable delay could cause a dangerous situation. It includes ministerial acts, where there's approval or ceremonial proclamations. And there's a specific group of meetings that are exempt from this type of, from the opportunity to be heard on a proposition, which include items like security, fire safety, competitive solicitation. And even though they are not necessarily an opportunity to be heard, they're not completely off record. And you should always seek the advice of one of the county attorneys when it comes to things that you think may need to be off record, because that varies in the requirements of what has to be recorded and the changing of dates when it might need to be released, or whether it's sealed permanently. Those types of things, you should always consult with your assistant county attorney before you make any decisions that you think something should be off record. That tends to affect more a level above of what you're dealing with. It tends to deal more with elected official boards. Then finally, quasi-judicial proceedings. And I noticed, I paid close attention to how you handled that today. And, you know, we don't want just public comment on those types of things. We want when you're dealing with a quasi-judicial proceeding, you're taking in evidence. So you're talking to witnesses, as you did, you swore in people and took in evidence. Penalties for violation of the Sunshine Law include a non-criminal infraction. That's for a non-knowing violation of Sunshine Law. It's a $500 fine. However, a criminal violation would include knowledge and would include a second-degree misdemeanor. It could include suspension or removal from the board, and could also cost you attorney's fees. Are there any questions? Do it now while Matt's here, because he's much better at this than I am. He's much more talented. Okay, if no other questions, thank you for your time.
Thank you.
Thank you.
Was it boring? Oh, there's a tough.
No.
I will
wasn't
say
boring.
that you provided history, which was nice, because
See, that's
typically they
good.
just tell us the
Now, that makes
rules.
it interesting.
All right, well, good. Thank you very much. I appreciate it.
Being no further business, we're adjourned.
Hey, thank you, staff, very much for the format.
Thank you.
I love that now. That's so much easier.
Very well done. Thank you for doing that class.
Yeah.